Hello, my dear friends, and welcome to Study IQ. I'm Joycey Joy, and today in this lecture we will discuss about AFSPA, sedition, and defamation laws in India. Now, if we come to the current affairs, there were certain recent happenings across the country against the individual rights and the right to free speech of individuals, and these happenings or incidents have questioned the relevance of certain laws in the country, especially the AFSPA, sedition law and the defamation law. So in this backdrop, let us understand what are these three laws and what is the significance of these laws and why they have become controversial, and is there a need to still continue with these laws in this country. So these will be the topics that we will cover in this lecture. But before we begin, this is our channel Study IQ, and we are providing pen drive courses for various competitive examinations including SSC and bank courses, UPSC optionals, SSC JE courses, teaching examination, railway examination, defense examination, RBI grade B, NABARD, UGC NET, UPSC civil services examination, law examinations for various state PSCs and also for various professional courses. You can visit our website www.studyiq.com for more details, or you can call to any of these numbers for more information. Now let us first understand the sedition law in India. Let us first see what is the meaning of sedition. So sedition is dealt in section 124A of the Indian Penal Code or the IPC. So this section is very important because it has been appearing in the news recently very frequently. So you can expect a question regarding sedition, AFSPA or anti-defamation law in the UPSC preliminary examination, which is due on 2nd of June 2019, because these three laws were in news frequently in the past few months. So one question is expected from this area. So if a question or a statement is asked on what is 124A of IPC, it deals with sedition law in India. So 124A of Indian Penal Code deals with sedition. And what is the meaning of sedition? Sedition refers to anything written, spoken or done that brings hatred or contempt against the government established by law in India. So if any person writes, speaks or does anything against the government, or something is done which will bring in hatred towards the government, it is called sedition. And in India, it is a cognizable, non-compoundable and non-bailable offence. And under the sedition law, sentencing can be between 3 years to lifetime imprisonment along with a fine. So these are the provisions of sedition law in India. Now let us understand what are the concerns in the sedition law in India. The sedition law was introduced in India in the year 1870 by the British. So since the introduction in 1870, the meaning of the term sedition as well as the ambit of the law has changed significantly. So when it was introduced by the British government in order to target and suppress the nationalist leaders or the nationalist movements. So this was the target of bringing in sedition law. And Mahatma Gandhi famously called the defamation law the prince among the criminal laws, which impacted the free speech in the country. And after gaining independence, in the Constituent Assembly, there were various discussions and debates whether to continue with the sedition law in India. But still, finally, the section continued to remain in force. And after that, various governments were formed in India after the independence, and successive governments have been accused of misuse of the provisions in the sedition law. Now coming to the revision of sedition law, in the year 1962, the Supreme Court had curtailed the extent of its application. So Supreme Court in 1962 curtailed the extent of application of the sedition law, but the Supreme Court had upheld the constitutionality of the sedition law. Supreme Court said that the sedition law is constitutionally valid and upheld its constitutionality. And the objective was to punish those who jeopardize the safety and stability of the state and create public disorder. So Supreme Court said that sedition law is necessary in order to punish those who act against the public order. But since the Supreme Court order, Many courts in the country, including various high courts in the country, have repeatedly observed that the section of sedition law, that is 124A of IPC, cannot be used to curb the criticism of the government. So, government cannot misuse it in order to deal with the criticism against the government. And various courts have observed that it can only be used as a measure for maintaining public order. Government cannot use this against any of the criticisms against the government. So now there are various criticisms that this section is highly misused, and there are various proposals that the section 124A of IPC, which deals with sedition law in India, needs to be revised. So this is sedition law. Now moving on to defamation law. Let us first understand what are the provisions of defamation law in India. And the defamation law is dealt in section 499 of the Indian Penal Code, or the IPC. So section 499 of the IPC deals with defamation law in India. And what is defamation law? Anything written, spoken, or done intending to harm the reputation of a person is said to defame the person. So if a person knowingly does something in order to harm the fame or the reputation of a particular person, it is known as defamation. And we have discussed about the defamation law in detail when we had taken the classes on the Me Too campaign. Now coming to defamation law in India, India is one among the very few countries where defamation law is both a criminal as well as a civil offense. And as a criminal offense, defamation is bailable, non-cognizable, and compoundable, and it is punishable with an imprisonment up to 2 years or with a fine, or both. Now, once charged in a criminal trial, the accused may prove that they are covered under any of the 10 exceptions to the section. So what are these 10 exceptions? For example, imputation which is truthful, or a statement which is made in good faith, etc. Now let us understand the defamation law elsewhere in the world. The English common law has different punishments for written and spoken defamation. But in case of India, we do not make a distinction. So defamation, whether it is in the written form or in the spoken form, India deals with it in the same manner. So there is no distinction in India. In India, both spoken as well as written defamation is covered under the section 499 of the IPC itself. And in US, there is a distinction between private and political defamation. So in case of private defamation and political defamation, it is dealt with different laws. In US, there is more burden of proof placed on the prosecution if it is political defamation. So political defamation is more complex than private defamation in US. But in India, there is no such distinction. Now, what are the proposed changes for defamation law in India? We have seen about the sedition law. So, like sedition, many governments have been accused of misusing the criminal law of defamation for suppressing legitimate criticism. So, considering the misuse, there are proposals for revising the defamation law in India, especially after the Me Too campaign. So, if the defamation law is removed from the IPC, Indian Penal Code, defamation would no longer remain a criminal offence. Then it will only be a civil offence. And for civil offence in India, there is no stipulated legislation, and it is guided by a judge-made law. So this is briefly about defamation law in India. Now third one is AFSPA. So AFSPA can be expanded as Armed Forces Special Powers Act. Let us first understand what is the purpose of AFSPA. So Armed Forces Special Powers Act was passed in the year 1958 for the Northeast region, and in the year 1990 for the Jammu and Kashmir. So the law gives armed forces special powers to control the disturbed areas. So AFSPA provides certain special powers to the armed forces in the country in order to deal with the situations in disturbed areas. And the government designates this when a region is in a disturbed condition, and this will necessitate the use of armed forces in aid of civil power. Now let us understand what are the provisions of AFSPA. Under the provisions of AFSPA, the armed forces are empowered to open fire, enter and search without a warrant, and also arrest any person who has committed a cognizable offence. So these are the provisions of AFSPA. AFSPA is very important for your UPSC Civil Services examination. You should definitely know what are the provisions of AFSPA. Notably, the armed forces have immunity from being prosecuted from this acts. So this is the most important provision. So if the armed forces open a fire or enter and search a place without a warrant or arrest any person under AFSPA, they cannot be prosecuted. And this provision gives immense power to AFSPA or the armed forces to misuse this. Now let us understand current status of AFSPA, or currently in which all places AFSPA is implemented. So this is also very important for your civil services examination, especially from the prelims point of view. There is every chance that UPSC can ask you a question on which all places AFSPA is being implemented. So currently AFSPA is implemented in Jammu and Kashmir, in Assam, Nagaland, and also in parts of Arunachal Pradesh and Manipur. So these are the places where currently AFSPA is implemented, and the law has been repealed where insurgencies have subsided. So wherever the insurgencies have come down, the law has been repealed. And in 2015, Tripura became the first AFSPA free state in the country. Now again in 2018, Meghalaya was also removed from the list. So this is also very important. Two states which were removed from the list, one is Tripura and second one is Meghalaya. The reason is that the insurgencies in these areas have subsided and the government have gained confidence in these areas of managing the region using the police force. So in Tripura and Meghalaya, this has been removed, and currently this is applicable to the states of Jammu and Kashmir, Assam, Nagaland, Arunachal Pradesh and Manipur. Now what is the contention behind AFSPA? There are criticisms within the country and also outside the country regarding the impunity under the AFSPA. And Manipuri activist Irom Sharmila had been on a 16-year hunger strike in protest against AFSPA. And in this regard, in the year 2004, a committee was formed, the Jeevan Reddy Committee, and this committee has recommended for a complete repeal of the law. So this committee recommended that there is a need to strike a balance between the powers of the security forces and the rights of the human beings as citizens. So this is briefly about AFSPA. These three laws are very important from your UPSC Civil Services examination point of view, especially in your mains examination. You can find the PDF of this lecture on my Facebook page, and you can also follow my Facebook page for more video updates, and please write to me at joyce.studyiq@gmail.com for any of your queries or for your suggestions. Thank you.